This is Kevin McNeely. I'm providing some practice tips on how to help your marijuana and cannabis clients get trademark protection. So if you take a look at the Federal Register, you'll see hundreds, if not thousands, of federal trademark applications for cannabis, marijuana, cannabis-infused products, and inevitably, at this point in time, they are dead on arrival. That is because under the Controlled Substances Act, marijuana is a Schedule I drug. As a Schedule I drug, you cannot make lawful use in commerce of that product, so the application is a non-starter. So, given that marijuana is still technically illegal under federal law, is it even useful to get a trademark? And my suggestion would be probably yes. And the reason for that is that, first of all, it appears that legalization may not be that far off. Younger people tend to view substances such as alcohol as far more dangerous than marijuana, whether that is true or not. I'm not sure. There's enough research to know. But also, the political landscape is probably going to change as marijuana gains financial and political muscle, and lobbyists start to advocate for marijuana the way they do for alcohol and tobacco. So that sea change may be inevitable. It may be a good idea to get your brand protected earlier rather than later. Also, from a point of view of how the trademark register is used, it can be very helpful to serve as a notice function. So what I mean by that is every day parties are engaged in clearance searches to try to find out if a brand that they want to create is available. If something else gets flagged on the register, parties tend to avoid using a confusingly similar name, and they might decide to go with another brand name that appears not to have conflicts. So from those point of views, it appears to be a reasonably good use of resources to go ahead and try to get a trademark application. Now, how do you go about doing that? Well, there are at least three different ways. One is consider alternative or peripheral filing categories for goods and services. The second would be to use state law registries. And the third would be if your client is producing CBD and hemp products, which have now been legalized. So, state law registries. If your client operates in a particular state, say it's a dispensary or a grower, each state has its own trademark registry. You could, in the states that do find cannabis and marijuana lawful, you could file in those states for marijuana products. States such as California, I believe Washington and Oregon have specifically amended their trademark laws to allow you to file for brand protection for cannabis products. Other states, you may end up filing in some type of agricultural product category, but these decisions, you'd have to look into state law and find out on a state-by-state basis whether the filing for trademark for cannabis is viable in that state. It is somewhat limited protection because technically these dispensaries operate on a state-by-state basis, so they'd be limited in filing to a state in which they operate and or are franchised or licensed. In terms of alternate or peripheral categories, you might want to look into if your client sells other products. For example, there's a company in Washington, D.C. that sells juice, and they also happen to gift you marijuana on the side for your purchase of some very expensive juice. Now, whether that's legal or not, I'm not going to get into, but they could file for brand protection for the juice that they sell. Alternatively, a lot of companies are involved in various types of marketing, promotional, research, education. There may be some category of provision of information that the client could file on. Of course, it has to be a legitimate use. You can't just simply make up a category that fits neatly into, for example, a First Amendment category, but the client's not really producing any information in that regard. So it has to be a legitimate use in commerce. Another area to explore is whether or not the client makes CBD or hemp-related products. At the end of last year, there was a farm bill that was approved, and the Controlled Substances Act was amended. And when that was amended, they basically allow for CBD and hemp products to be sold. And now the Trademark Office has acknowledged that, and they are allowing applications on CBD and hemp products that don't include more than, I believe it's 0.3% of THC by weight. So those are your three areas to explore of potential ways to get brand protection: state law, peripheral categories, and CBD or hemp product sales. In terms of, for the practicing attorney, in terms of a couple of good takeaways, I think you have to be careful that you don't make any misleading statements in your applications that might come up when, for example, say you're selling brownies. If you don't include, first of all, if you include that they are cannabis-infused products, you're not going to get a trademark. But if you leave that out, you could get a trademark, but on the other hand, it could be invalidated as soon as it's challenged. So you have to avoid getting yourself into a situation where you end up with a misleading statement by omission. Secondly, I think, and this is the most important takeaway, I think, is that you probably want to file, if you're going to file for peripheral categories, alternative categories under the Patent and Trademark Office filing system, you probably want to file a use in commerce application, not an intent to use application. And the reason for that is your application is probably going to get a fairly high degree of scrutiny, and if you make any small mistakes in terms of how you classify goods and services, sometimes you end up in the wrong class of services, and the examiner requires a change to that. Well, that's a lot easier to fix when you make a use in commerce filing. When you make an intent to use filing, if your specimen that you ultimately file does not match the information that was provided in the application, you could end up with a material alteration that is fatal to the application. So, if you're a practicing attorney, I'd like to hear from you if you have some creative solutions to how to assist your clients in if you've come up with some ways to help them despite these kind of unique and special legal issues involving marijuana and cannabis. And thanks, and that's all.